Test one, two. 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 Can you hear me, Ruth? Ruth, can you hear me? Wave if you can hear me. I'm at the other end of the hallway. Oh, sorry. I'm like right behind you, so you can wave at me if you can hear me. Okay, good. All right, we're live. It's 10 seconds. It's the streaming software. If I go inside there, can you hear like the noise of the?
Denise, just hi. How are you?
We're good. We're live. Audio's good.
Denise was asking about a microphone.
Yeah, so we're gonna use this for the
So she all set?
just body pack. Yeah, we have this one too, but it's gonna be weird if there's no speaker and someone's just talking into that. So I figured.
Okay.
Yes.
Test 1 2. 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 Oh. Test 1 2. 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 Test 1 2.
And it's live. Is this live streaming? Is this good? Okay. All right. Welcome everyone to the C2C Community Fair. Thank you for checking in with us today. I'm going to do a quick introduction of our event and what you can expect here. So my name's Zoe. I'm a community organizer here with C2C. As you can see, we have lots of resources all around the room for you to access today. So you checked in. We have class registration table back there where you can sign up for free ESL, GED, digital literacy computer classes, and you are also able to test on site. So if you go to that table, you can register, test on site today. We also have Pathways to Housing, Montgomery College. We have HBI here. If you want a wellness screening, you'll have the option of a blood prick or a finger prick, which will give you rapid results, or a full lab test that will get sent to you. We also have the Department of Labor here. We have an Immigrant Resource Center. We have WorkSource Montgomery, Montgomery County Public Libraries. And we also are going to have a room right out there. We can have people direct you down the hall to resume and interviewing help. So if you want help working on a resume and interview in small groups, one-on-one, head on down the hall to get that interview and resume writing help. So now I'm going to introduce the first workshop that we have for you here today. So Montgomery Bar Foundation, the Pro Bono Project, is here, and they are going to be presenting 2 workshops today. We have immigration law here, which is going to start in just a few minutes. And we have these chairs set up. If you want to come, sit down, ask some of your questions. And then from 3:30 to 4:30 p.m., we're going to have a family law workshop. And again, if you'd like to participate, ask some questions, feel free, come up to these chairs and sit down. And we will get that started in just a few minutes. So again, in this room, we have all of these wonderful vendors who are here with us today. Down the hall, we have resume and interviewing help. And we have a class registration table. If you'd like to sign up for one of our classes, you are able to test on site and you will be directed to that room. All right, thank you for being here today, and I am going to turn it over to the Pro Bono Project, and we'll get that started in just a couple minutes. So again, if you'd like to come up and listen and ask questions, come to these chairs up here. Okay. I'm going to check in about the mic real quick. And
yeah, that's and also I do the family law.
Family law, oh, okay. So immigration first and then family. Yeah.
Okay. Okay.
Okay, so yeah, immigration first and then we'll do family. So immigration, we have from 2 to 3 set aside for you. I'm going to see if we have the mic ready for you, so just give me 1
Sure,
minute.
take your time.
Okay. Is there a mic for them, or?
I have to mute. Now you're live.
I'm live? All right. Okay. How are we going to do the transition, or are you just going to talk? How do you want to do it? Okay. I feel like Steve Jobs, you know, he used to walk back and forth, you know? Sir, whenever you're ready, I guess I'll... Immigration. See?
Workshop starting there.
2 minutes? 2 minutes? Okay, 2 minutes. I don't want to create any. I'm still 2 minutes or now?
2 minutes, and flip that switch again if you want to mute yourself.
Got it. Well, I think it's just testing. Can you hear me? Okay, good. All right. We're good? All right, we'll get started. All right. Good afternoon. If you're interested in a primer on immigration law, come this way, please, and we'll take about an hour to go over the do's and don'ts, the ups and downs, and sideways on immigration law and procedure. Okay? Thank you very much. Anybody else? Otherwise, we'll get started right now. Okay. Good afternoon, folks. My name is John or Jonathan Kaplan. I am a retired federal employee. I worked at DHS for about 15 years. Eva Zhu is here. Two of us are going to do a presentation on basically a primer on immigration law. I now teach American government at Frederick Community College and volunteer for the Montgomery County Bar Foundation, so I'm here on behalf of the Bar Foundation to explain basically a primer on immigration law. Okay. So let's get started first concerning the issue of immigration law, okay? Basically, what you have immigration law, you have two types of immigrants. You have non-immigrants and you have immigrants. So non-immigrants are those who came to this country, okay, basically as a temporary visitor. So it could be, for example, you're here on a tourist visa, a business visa, a student visa, a work visa, circumstances like that. You're here temporarily, okay, with the intent being that you're going to return to your home country. Okay. Then you have immigrants. Immigrants are here who intend to come to the United States and live in the United States. Okay. Basically, standing as a resident of the United States. Whether you become, stay as a lawful permanent resident, okay, or become a United States citizen, okay, you're here to live, okay? So the difference is basically, if you're coming here, okay, as a non-immigrant, okay, depending upon what country you're from, okay, you may qualify what's called visa waiver program, which is basically if you're from a European country that you get to come just with your passport and you get to stay for 90 days and you have to leave, okay? If you come from other countries, you have to apply for a visa. And that means you have to go to the U.S. Embassy in the country, the capital of the country you're from, okay? Apply for a visa, you know, be interviewed and determine whether in fact, you know, the embassy official or consulate official allows you, stamps your visa and allows you to come to this country, okay? With those conditions, okay, you know, if you're a non-immigrant, you're here for a certain period of time, then you have to leave, okay? If you're an immigrant, that's a different situation, okay? We can cover quickly in terms of what it takes to become an immigrant, okay? Basically, there are two forms, okay? One is family petition, the second is employment, okay? So family petition is basically you have a United States citizen child, okay, who's over 21, okay, or parent, or a relative, okay, who's sponsoring you to come to the United States. Now, depending upon your circumstances, you may be able to, you know, come in, you know, without the quota system, okay, or otherwise you're subject to the quota system, which could be 20, 30 years before you actually get to come into the United States. So circumstances, your best bet to come in if you're coming as an immigrant is, for example, if you're married to a United States citizen and your citizen spouse sponsors you, okay, to come to the United States, then you go through the process depending upon if you're in the United States already or if you're back in your home country. You go through the process. If you're approved, your passport gets stamped, you get a green card, okay? If you're married, for example, you get a conditional green card, which is good for 2 years, okay? Assuming the marriage is legitimate, okay? If the marriage is turned to be illegitimate, okay, then you could face deportation, okay? If you want, for example, if you're a United States citizen, you want to sponsor a parent or child under the age of 21, that's another way to come to the United States, okay, on an immigrant visa, okay? Broad brushstroke, any questions about that? Okay. Next thing we're going to see, any questions? Okay. Next thing we're going to take, oh, I'm sorry, question? Yes, ma'am.
If the marriage is dissolved by domestic violence and
domestic violence, yes.
You,
okay.
2 years of green card and then to renew for permanent residence, what's the steps to?
Okay, the question is if a non-citizen spouse faces domestic violence, okay, or no, a citizen faces domestic violence, yes. or the non-citizen?
Citizen.
The citizen faces domestic violence? Okay, so you're saying the non-citizen committed domestic violence against the citizen, and it's within 2 years of the marriage? Okay, well then of course you can dissolve the marriage because, you know, that's abuse. So you can dissolve the marriage. The person then becomes eligible for deportation. Okay, because within 2 years, okay, that's the bar. Okay, if the bar clears 2 years, then the conditional green card or conditional lawful permanent residency gets removed, and the person becomes subject to deportation. Okay, that's a answer. I'm sorry?
No option for that?
Well, you can obviously the non-citizen can apply to stay in this country. There's the limited avenues for relief for that person, but the short answer is if the person committed domestic violence, okay, it's within 2 years, that person is going to ultimately be removed from the United States, okay? Because the conditional status is removed, okay, and the person becomes eligible for deportation, okay? So let's take up the issue concerning deportation, okay? This is a big issue that comes up, okay? When I worked for Immigration and Customs Enforcement, ICE, this was our bread and butter, okay, on the immigration side. So how is it you can be deported from the United States, okay? Couple straightforward ways, okay? You overstay your visa. So you're here, okay, let's say for instance you're from the United Kingdom and you're here, you know, you're allowed to stay for 90 days, but you say, I like it here, I like it a lot. So I don't want to go back to the UK, I want to stay, okay? And you overstay your visa, okay? Once you overstay your visa, okay, that's it, okay? As a visa overstay, that's grounds to be removed from the United States because you violated the terms, okay? If you have a visa, same thing. You overstay your visa. That's an easy way, okay? So the period of time when it runs, if you stay past that, okay, you're now, you know, subject to deportation, okay? Second way, you're a student. Easy way, I teach at community college. So one of the things we had to do in teaching, concerns making sure, finding out who the non-citizens are in our class and making sure that they attend. Because if they don't attend, guess what? That's grounds basically to say, the school is going to say, you're not attending school, so the reason you're here on an F visa, okay, you violated the terms, okay, you didn't comply, so we're going to remove your status. So we're going to contact the United States Citizenship and Immigration Service, the CAS, to let them know that you're out of status. Now you're out of status, guess what? You're subject to deportation. Another way, you're here on a student visa, okay, or a tourist visa, and you work, okay? That's a no-no. You have to get special permission to work. That's called an employment authorization document, EAD. No EAD, you can't work. You get caught working, you violate your terms, your grounds to be removed, okay? Those are straightforward ways in terms of being removed from the country, okay, for violating your terms. Now we have a situation with committing crimes, okay? There are all kinds of crimes you can commit, okay? Hopefully no one here commits any crimes, but if you do commit a crime, okay, certain crimes, like for example, possession of marijuana, okay, low possession of marijuana, you could basically, in many circumstances, you could avoid the prospect of being deported for low possession. That's possession, not distribution, that's not selling, okay, let's be clear about that. So if you're caught selling, that's a different story. Possession, minor possession, okay, you can avoid the risk of deportation. The big things concern two big things. One's concerned a CIMT, which is crimes involving moral turpitude. So for example, you lie to an immigration officer, you lie in court, you get convicted, okay? That's a crime involving moral turpitude, okay? Depending upon your CIMT, you could face deportation for that, okay? Any questions about that? Next thing, aggravated felony. If you're an aggravated felon, that means you committed a crime that involves a sentence sentence can be imposed in excess of 1 year and 1 day, like a felony. That doesn't mean that you actually went to prison for more than 1 year and 1 day. You could go to jail for 10 months, but your sentence, could face 2 years, but the judge decided to cut your sentence, okay? Commute your sentence for whatever reason, okay? But nevertheless, you were convicted of an offense where the punishment is in excess of 1 year and 1 day. That's an aggravated felony. And this gets important concerning what type of relief from removal you can get depending upon, the circumstances of your crime, okay? Any questions about that? Again, it's a very broad brushstroke. We can get into more details concerning different offenses, but that's a broad brushstroke concerning what grounds you have for being removed from the country, okay? Any questions about that? Yes, sir.
Driving under the influence.
Yes. Can you be removed? Yes. Yes, you can. Now, a question comes up before. I'm a green card, okay? I'm a lawful permanent resident. I've been in this country for 25 years, and I went drinking with my buddies one time, and I got pulled over, okay? And now they're trying to deport me. Can they do it? The answer is yes. Yes, they can. This happened, in fact, the Post had an article a few years ago about this with a woman, I think, from Spain. And she was in this country for like 25 years. And she got caught once, okay, for DUI. This is the Trump administration, like, we're gonna remove people for doing this. So yes, okay. She tried every single avenue possible to stay in this country. At the end, she was unsuccessful. She could be removed, because that's DUI, okay. Now, depending upon the state, you could perhaps try to knock it down. Have counsel try to knock it down for the first offense, okay. For example, in Maryland, we have what's called probation before judgment, PBJ as we call it, okay, which is a form of, in the federal practice, we had pretrial diversion. Pretrial diversion would basically, you stay clean, you do the right thing, you go, you go to the training classes, you don't have any other offenses, okay, it'll be, there'll be no conviction entered onto your record, okay. I'm not sure if Virginia, I think in her case it was Virginia. But yes, you can be removed from this country if you committed driving under the influence. So things come up concerning what's the difference between, those, for example, non-immigrants, okay, or those here, for example, on a visa, as opposed to being a green card, okay? Can you be deported for being a green card holder? Yes, you can. Yes, you can. You commit offenses, you can be removed. People don't know this. They've been in this country for 30 years, and they've thought at the time, well, if I have a green card, I'm immune. They can't touch me. No, that's not true. If you're a green card holder, a lawful permanent resident, you commit certain offenses, you can be removed from the United States, okay? So, what's the easy fix to that? Well, if you're eligible to become a United States citizen, I highly encourage you, assuming you qualify, to become a United States citizen. Because if you become a citizen, guess what, okay? As long as you didn't, lie or falsify information on your naturalization application, any offenses that you commit after you become a citizen, we're stuck with you. You're a United States citizen. We cannot remove it, okay? That's a short answer, okay? So that concerns basically the issue of a deportation or being removable. You had a question, I believe?
Yeah, my name is Rico. The question is from Marty.
Okay.
She want to know for people who come to the US by the border, like Mexico.
Mexico, yes?
Yeah. What can remove them from US?
I remove from the United States means?
Yeah. What can remove them?
What can we move someone from?
Yeah.
Well, how did she come to how did she arrive in the country if she wants to share? Did she come to this country just cross the border, or what did she do?
She's probably way up.
To move forward this, why don't we take this up in terms of clinic, okay? So we can address our personal issue, okay? Any questions concerning removability, okay? Any questions about removability, okay? Basically, stay within your time frame. If you're a non-immigrant, hold on. Stay within your time frame. Don't commit crimes. Please don't commit crimes, because that's an easy way with which to be removed from the United States. Okay? Even the Biden administration is removing people who commit crimes, especially contemporaneous crimes. Okay? You had a question?
Maybe this goes to your non-immigrant, but like if someone has no status, they've
Yes.
been through the border, they have no status of entry.
Yes.
What are their options?
Okay, we're going to get to that. That's called relief from removal. Okay? So, that's called basically if you arrive to the United States and you don't have a visa, you don't have permission to enter the United States, it's called being paroled into the United States. Okay? Then you call what's called an EWI, which is entry without inspection. You were at the border, you knocked at the door and said, "Hi, I want to come in," okay? And you arrived, okay? You entered the United States territory, okay, without authorization, without permission, okay? That's entry without inspection, okay? So, thing comes in, when you arrived, it's gonna be, why are you here, okay? I'm here to seek asylum, which we're gonna cover real soon. I'm here to seek asylum, okay? I'm here to seek withholding. I'm here to seek Convention Against Torture. I'm seeking here because I'm a child. I'm applying for special immigrant juvenile status because I qualify. Okay. These are just some examples. Okay. I'm being trafficked. Okay. I came in, okay, to be trafficked. It could be for, I was basically commandeered to do drug trafficking, sex trafficking, work. Okay. Illegal work, which of course you may have been reading about in the papers concerning that a number of young children who work in the slaughterhouses in the Midwest. Okay, that's being trafficked. That's grounds to seek relief from removal. Okay, the decision's made at the border that you have no grounds, okay, for seeking relief. Okay, for example, you apply for asylum, and an asylum officer meets you and says, "Nope, you don't qualify." Okay, you don't meet the criteria for, it's called a credible fear interview. You don't meet the bottom line. Okay, you're subject to what's called expedited removal. And that means you're basically turned around and you're sent back, okay? Now, something else to keep in mind. May 11th, I think is the date, right, when Biden said he's lifted? It's May 11th or May 13th? I think it's May, what? May 13th? Okay. We think it's May 13th and maybe May 11th, but early to mid-May, okay, the Biden administration has announced it's going to end Title 42. So I'm sure you all heard what Title 42 is. Anyone? Okay. Title 42, okay, was a measure that the Trump administration imposed back in 2020 to address COVID. And the idea was that he declared a public health emergency in the United States and said basically, you cannot enter the country, okay, without permission. So if you arrive at the border and you're knocking, okay, and you're speaking two things, inspection and admission, we're not gonna allow you in the country, turn you right around, okay? Under the authority being Title 42, so it's 42 United States Code, Section 365. Subject to a lot of lawsuits, as we know. The Biden administration decided that the issue of COVID is no longer a pandemic, it's an endemic, it's no longer a national emergency, so Title 42 is going to end. So that's no longer a reason with which to remove, potentially send people back across the border, okay, without being processed, okay? So we're expecting a significant number of people, non-citizens to arrive at the border beginning in mid-May, okay? So we deal with the issue in terms of expedited removal. You don't meet a credible fear interview pass, okay, you're sent immediately back across the border, okay? That's called expedited removal, or ER as we used to call it. So the other issue comes up concerning how is it you can seek relief from removal? whether you're an entry without inspection, EWI, okay, or you're in this country already, okay, and you have grounds to seek relief, okay. The principal ground, probably where most of you are here, is called asylum, right? Okay. Now the issue is, what is asylum? Asylum basically is just like it says, asylum, you're allowed into this country and you can stay, okay? Basically, it's a way with which a pathway from asylum status to become a lawful permanent resident, a green card, and ultimately a United States citizen, okay? If you're granted asylum, okay, that's the pathway. No matter what your circumstances are at arriving at the border, okay, if you qualify, okay, you gain status, and from status, you can become a green card and become a United States citizen. Now the question is, how do you get, what is the issue in terms of establishing asylum, okay? Many people cross the border and they think, well, I'm from Venezuela, I'm from Colombia, I'm from Peru, I'm from Mexico, I'm from elsewhere, Cuba, okay? And I want to come to this country and I'm claiming asylum, okay? Is that reason alone to apply to gain asylum? No. So how do you get asylum, okay? You have to have either face persecution or have a well-founded fear of persecution based on race, religion, nationality, membership in a particular social group, and political opinion, okay? So if you're here, okay, for economics, I'm from Peru. I had a client months ago about this. I can't find work in Peru. No work, no job, okay? Government is basically saying, we're gonna take punishment against you for, take away all jobs, okay? So I'm here to work. You're basically determined to be an economic migrant. And economics is no reason to apply for asylum. You'll be denied. You can't come based on economics. It has to be, okay, a well-founded fear or experience persecution based on your race, your religion, nationality, membership in a particular social group, or political opinion. So, what's an example? You speak out against the government. You have an issue in, let's just say Venezuela, because of course with Maduro. So you spoke out, and there's evidence that you spoke out against the government, and they took action against you, okay? They persecuted you based on your political opinion, okay? Do you qualify, okay? You may, okay? Because you have a well-founded fear or you experience persecution. Now here's the thing with persecution. Does it have to be the government persecuted you? Yes and no. Yes, there has to be evidence that the government persecuted you, or that there's a private entity or private party that persecuted you and the government did nothing about it. So you got examples, for instance, of gangs that have hit, for example, areas like El Salvador, okay, where they've tried to basically commandeer young men to join their gangs, and they're like, no, I don't want to join. So they face all kinds of, abuse, okay. They contact the government, they contact the local magistrate, help us out here, deal with these gangs. Government's like, we can't deal with it, we don't want to deal with it, not our problem, okay? Is that a situation you may qualify for asylum? Yes, you may, okay? That's an example, okay, of seeking of asylum. Now you have two forms of asylum. You have defensive asylum, you have affirmative asylum. So affirmative asylum is that you go in, you say, before removal action is taken against you, you're immediately here to seek asylum. That's called affirmative asylum. Defensive asylum is when the government's saying we're going to issue an NTA, which is a notice to appear, okay, for you, basically a show cause order why, you should stay in the United States, which is basically we intend to remove you from the United States. That's defensive asylum. At that point, I'm applying for asylum. Now here's the thing. When do you have to apply for asylum? 1 year of arrival. Okay? If you're past 1 year, it's an extraordinary hardship why you couldn't apply. The short answer is, if you missed the 1 year deadline, your chances of your asylum application going forward are slim to none, okay? Make sure you do it within 1 year of arrival, okay? So, what evidence do you need? Well, obviously your word counts a lot because you file what's called an I-589 application, okay? Your word carries a lot, but you're gonna want more than just your word, like I face persecution, this happened to me. Because what's going to happen is it's going to be the government's going to prosecute, is going to do the case saying, this is her word, she has no other evidence behind it, okay, other than her assertion, okay? And that's not going to get very far with most immigration judges, okay? They're going to deny it. So you're going to need evidence concerning you contacted the police, you contacted the law enforcement authorities, you contacted the government, and they did nothing for you, okay? And you have proof that you wrote letters, okay, that you appeared. You have photographs of demonstrations you attended. Let's just say hypothetically you were in Caracas. All right? and you're there in Caracas and you're demonstrating against the Maduro regime, and you've got evidence that you were there, okay, you demonstrated, and this is what happened. You know, police came in, they used batons, they start beating up people, okay? That's evidence, okay, of political persecution. Do you follow me? What's another example? Membership of a particular social group. There are many communities where homosexuality is illegal. I know in Uganda, for example, I think it's a death penalty, if I'm not mistaken. Okay, so let's just say hypothetically you're from Uganda. You're from Uganda and you're gay, okay? Or you're from a community in Latin America where people who are gay are persecuted, okay? That's being a membership of a particular social group. If you can establish, okay, that in fact you are gay, then in fact that may be grounds with which you can then claim asylum, okay? These are just some examples. But the biggest thing, the biggest hurdle non-citizens face is evidence, proof that in fact you deserve asylum. You suffered persecution. Because most people come in, they don't know how to do it, which is why you need counsel. Most of the time you need counsel to help you out. Because you're going in against the government, which has an attorney, that's going to prosecute you for your removal, okay? So, most important thing is, if you have evidence, if you have family members back home, okay, to gather all evidence, all records you have establishing your claim for asylum. Any questions about that? Okay. There are some bars to asylum besides the 1 year limit. One bar, for example, is if you're an aggravated felon, okay, you cannot claim asylum, okay? If you were removed from the United States, okay, so you were removed, you got an order of deportation, you got to leave the country, they pick you up, they put you on a plane, they send you back to where you're from, okay? You are not eligible for asylum if you have been ordered removed. So what's your remedy then, okay? It's called withholding of removal, okay? Withholding, okay, is a higher bar. So concerning proof for asylum, they call it really the 10% rule, which is basically, can you make a case, okay, that you face a well-founded fear of persecution? Now again, let me say something else about asylum. On average, across the United States, only 15% of asylum claims are granted. Only 15%. It's a very small percentage. The bar is low for asylum. The bar for withholding is higher, okay? So as I said, the 10%, if you make a case for 10%, okay, that's sufficient usually for asylum. For withholding, it's 51%, preponderance of the evidence, okay? It's a higher bar. Now, if somehow you were able to make a claim for withholding, what's the issue? Well, the issue is the government withholds your removal, won't remove you to your country. However, okay, the government can remove you to a third country, okay? So hypothetically, okay, lady here in front, okay, let's just say she's from Nigeria. And she applies and her withholding application is granted, okay? But let's just say Morocco's like, oh, we'll take her. Well, guess what? The United States can put her on a plane, send her to Morocco. She has no rights to deny that because third country removal is permitted, okay, for withholding of removal, okay? Next thing is Convention Against Torture, which is basically, if basically all other avenues are exhausted, you can't claim any relief, for example, for aggravated felon, but if you go back to your home country, you're going to face torture, okay, which is basically a form of violence against you, okay, including murder, okay. That again is preponderance of the evidence, okay, and depending upon your circumstances, you may be granted Convention Against Torture, which is torture, you can't be removed to the country, or more likely what happened when I worked for ICE, it was we called DCAT, Deferral of the Convention Against Torture. Deferral was basically, as long as the country's conditions are that you face torture, we're not going to send you back. But a new government comes in, guess what? There's no longer an issue concerning torture, so we're going to send you back. That's CAT. Okay? Any questions about that? Okay. So, you want to take SIDGE? You want me to take SIDGE? You want to take SIDGE? Okay. So, SIDGE. SIDGE is Special Immigrant Juvenile Status, okay? This is when a child arrives at the border, okay, with one parent, okay, or no parents. They arrive at the border, okay, and they're claiming, okay, so that they've been abandoned by at least one parent, okay, when they arrive at the border. So it could be abandonment, could be death of a parent, it could be the parent simply abandoned them, ignored them, whatever, just, distance themselves. There's no longer an economic or familial relationship with that parent. Okay? It's a pretty high burden to show, but you can show it, okay? So, what happens is a child comes in and claims they want to apply for what's called special immigrant juvenile status. And they have to show that at least one parent has abandoned them, or both parents have abandoned them, okay? And that they have to go to the court for what's called, the state court, for what's called a predicate order. So you have to go, for example, in Montgomery County, family court is the circuit court. So you have to go to the Montgomery County Circuit Court and ask a judge to enter an order, it's called a predicate order, that basically says you are either a ward of the state, okay, or you're under the control of a sponsor, presumably a parent, an uncle, a family member, okay? It's not in the best, and the other thing is, it's not in the best interest for the child to return to the country of origin, okay, or last habitual residence, because there could be an issue of violence, it could be an issue of persecution, it could be an issue of something in child not being able to receive an education or be fed. So we have circumstances, for example, where the child arrives at the border, was living with the grandma, okay, grandma died, no one else is there. So the child basically was on his or her own and could face starvation, okay, or who knows what kind of violence could be taken against the child. That could be grounds in terms of saying it's not in the best interest for the United States to send you back, okay, under those circumstances, okay. You can also face circumstances where the child had physical, verbal, sexual, or psychological abuse. Okay, that's another reason with which to apply for SIDGE. Okay, but generally it's referred to as abandonment. As I said, it concerns lack of familiar support, lack of emotional support, okay, and lack of economic support. So what happens if you meet this criteria? So you have a child who's applying for special immigrant juvenile status. The state court has entered a predicate order. What's the next step? Well, the step is to file what's called an I-360 application. Okay, the I-360 is the application where you're basically contacting the United States Citizenship Immigration Services to say, we have a predicate order, we have a child who's here on his or her own, or with one parent, and has no way to go home. Okay, CIS then reviews the application, decides whether to grant it or deny it. Okay, that's something to keep in mind. What's the age limit before a person can apply? Under age 21. Used to be 18, under 21. Now, the good thing is the law changed in 2008, so now basically you're grandfathered forward. So let's say you apply at the age of 20 years, 6 months, okay? And it takes forever for CIS to get around to your application. Are you still good? Yes, because you applied before the age of 21. The old rule used to be you had to apply before the age of 18, and the government had to resolve your application. So the government said, oh, you're 18 years in one day. Well, guess what? You are out. You were ineligible for SIDGE. You will now face deportation. That has changed. So as long as you get your application in before the age of 21, you can move forward. So CIS then reviews the application in terms if the child qualifies for special immigrant juvenile status. If the child does get SIDGE, okay, a couple of good things happen. One, you get status, okay? That's a big deal. Because when you have status, okay, that's a pathway to becoming a green card, to becoming a United States citizen, okay? Two, if you get SIDGE, okay, you can work, you can go to school, you can pursue other opportunities, okay? That's the benefit of getting a SIDGE. Now, keep in mind, for those of you who are parents here with a kid who's applying for SIDGE, the SIDGE benefit, the Special Immigrant Juvenile Status benefit, applies to the child alone. Okay? It doesn't apply to mom, it doesn't apply to dad, it doesn't apply to brother or sister, it applies to the child alone. That's number one. Number two, a SIDGE applicant gets SIDGE, gets a green card, becomes a citizen. Can the citizen now say, I want to bring mom and dad into this country? Why not? Or, the answer is no. The benefit's only for you and you alone. It doesn't apply to anybody else. So, you got to think strategy-wise. If you're here with a child, okay, and the other parent has abandoned the child, okay, whether it's beneficial to apply for SIDGE. Because if SIDGE is granted, it's going to be for the child and the child alone. It will not be for the parent, okay? It will not be for anybody else, okay? Any questions about that? That's a big deal, okay? But SIDGE is a very good remedy. Okay, U visa and T visa. A U visa basically is you cooperated or assisted in the prosecution of someone for a criminal offense. Whether the crime was committed against you or committed against somebody else, whether you're testifying as a victim or you're testifying as a witness, okay? You may qualify for what's called a U visa. Now, it's a difficult process, it's time consuming, and there's also a quota. There's a cap on how many people can get a U visa, okay? It is an option. Now, what's the advantage of getting a U visa? Well, again, the biggest thing is you get status. If anything you take away from this, whether kind of relief from removal you get, the thing to keep in mind is you want status. Because if you don't have status, then you can be removed. Okay? That's the big thing, status. So U visa gives you status, and if your U visa is granted, again, you can apply to become a green card, and then ultimately become a United States citizen. Okay? A V visa, or Victor, okay, is for trafficking. So trafficking comes in all kinds of forms: sex trafficking, drug trafficking, work trafficking, all kinds of things. So as an example, you may have heard of those children who've been working up at the slaughterhouses, okay, in Iowa, okay? That would be a good example of being trafficked. They were brought to this country, okay, to work in these plants, okay, because unemployment's low in these areas, and they don't want to pay these people anything. If you can make a claim that you've been trafficked, okay, that's a V visa. And as a V visa, again, same process. It's a way to become a United States citizen. Any questions about U or V? All right, so let's cover VAWA. Violence Against Women Act, okay? This concerns basically, it provides to male and female children, it also provides to spouses. Now the issue is that that your spouse has to be a United States citizen or a lawful permanent resident, a green card, okay? So if you're here, let's say for instance, hypothetically, you cross the border with your boyfriend or your girlfriend, you're here in this country, okay, and your spouse and your significant other commits violence against you. Can you qualify for VAWA? No, you cannot qualify for VAWA. It has to be a spouse, it has to be marriage, okay? Not, living together, cohabitating, not boyfriend, girlfriend, okay? It has to be, a marriage contract, okay? It has to be a spouse before you qualify, okay? It can be physical abuse, it can be emotional abuse, it can be mental abuse, okay? So all kinds of forms in which to establish abuse before you qualify, okay? And the other thing is a child has to qualify as a child as defined under immigration law, which is basically under the age of 21. And the person who's applying for VAWA has to be of good moral character, okay? Which is a whole kettle of fish concerning basically, you stay out of trouble, you've done the right thing, you're out of, the balance of equities favors you, you're good to go. But you have to have good moral character. If you don't have good moral character, you don't qualify for it. So, the other thing you got to look at is marriage is made for the sake of a green card. This happens sometimes where people get together, okay, and basically it's engaging in marriage fraud, okay. You know that you don't love this person. You have no intent to make a commitment and build a relationship. You're just here to get a green card. This is your vehicle, okay. If you have a situation like that, that's fraud, okay. If there's fraud, okay, there's no VAWA, there's no relief. So you have to think about that as well. Okay, any questions about that? Yes?
They say that the United States citizen.
Yes.
And start abusing.
Okay.
Start abusing.
Sorry,
and
yeah.
you got 2 years guaranteed green card.
Okay.
After that, you file abusement.
Yes.
And what the status is going to be, the green card?
Well, the green card, if it's after 2 years, and assuming that CIS has cleared the marriage, believing that the marriage is legitimate, it's bona fide marriage, okay, then the conditional status is removed and now you get a green card. So you wouldn't need VAWA status, in other words, okay, if the condition is removed and you have a full green card. Do you understand what I'm saying? That's a 2-year bar, 2-year limit, okay? If you clear the 2 years, you can move forward with getting your green card. If you're under 2 years, then you may have to look at that as a way in terms of seeking status in the United States, because obviously if there's abuse, there could be grounds with which the party can divorce the person, in which case the condition then is removed and now you're subject to deportation. Do you see what I'm saying? Well, again, if you're married for less than 2 years, okay, and the marriage falls apart, okay, and the party's divorced, okay, then the idea of being a conditional green card no longer applies, because now you now are subject to deportation. You did not meet the criteria to stay in this country. If you come to this country and you marry, it's called marriage fraud amendments. You have to be here for at least 2 years before the conditional green card status is removed to become a green card, okay? Less than 2 years, you're subject to be removed because of the divorce, okay? The defense around that would be, if you're under 2 years and your spouse is abusing you, physical, mental, emotional, sexual abuse, okay, you then can apply for VAWA because you're married to a United States citizen spouse. okay? And you can apply for status that way, okay? Because the marriage fell apart in 2 years. If it's after 2 years, you got your green card, see? So you don't need VAWA anymore, correct? That's my understanding. You don't need VAWA anymore, situation like that, because you got your green card, okay? Well, green card renewal is different. That's different. That's a whole different comment. You have to renew your green card after, I think green cards are good for 10 years? 5? Yeah, 10 years. 10 years. 10 years, you have to renew your green card. So you have to renew your green card, okay? But the point is that it's a way with which to seek relief from removal, okay? So it's 2:47. Do you want to take some issues or take this?
Oh,
No?
You give almost it.
Okay.
People. So, what's wrong? What else you did? What else you didn't cover?
Oh, I didn't cover cancellation, and I didn't cover.
Then maybe you can talk about those things later, right?
You?
I will. No,
The only thing I was to cover otherwise would have been admin closure and dismissal.
Yeah, you can talk about that. So my name is Eva Xu. I'm an attorney in Rockville. Is that okay? Is that okay?
If you take that part out. Where's, can you clip it to the belt loop? Yeah, that'd be better. I think it's the movement that's.
It's okay.
I think.
It's okay.
We'll get our tech person to make sure, but.
So I think you cover almost everything. So maybe just talk about it, but the hardship, extreme hardship.
Sure. Do you want to finish up with respect to admin closure and you can pick up, or how do you want to just take up to you?
No, you can finish everything.
Okay.
You can finish whatever you want.
Okay.
And close everything. Okay.
It's turned off completely, so
Is it on?
Yeah, can you clip it really high up, like on the collar?
what is this one? Family law?
Okay.
Thank you.
Is that okay?
Yeah, immigration or switching after.
Immigration. Yeah, little bit immigration. Yeah, a little bit immigration. Then John will continue close on the immigration.
For immigration assistance, there is an immigration workshop going on. Immigration workshop.
Hi, my name is Eva Xu. I'm an attorney in Rockville, Maryland. I'm practicing immigration and family laws. So day in and day out, I do face many questions regarding immigration and family law. Sometimes, this is a perfect match because sometimes the immigration concerning marriage, divorce, and what's the consequence. So John did a great job. He covered almost all aspects about immigration law. So I will just talk a little bit about the situation regarding extreme hardship. Like John said, in case like a SAGE, S-I-J, special immigration juvenile case, the children who got protected with the status, but their parents cannot get those status, right? So in other cases, like parents came to this country crossing the border without status, their children were born in this country. So when the children are turning 21, then they can sponsor their parents. If the children, is able to sponsor the parents. However, the problem is the parents came here without paper. Like John said, they call EWI, enter without inspection. So one of the solutions is called provisional waiver. This also applies for married couple, spouse. So that process goes, the children or the spouse, the U.S. citizen or permanent resident spouse, first apply with immigration a family-based petition. After this, the first step approved, then this case would be transferred to National Visa Center, Department of State, with a case number issued. The third step is, once the National Visa Center case number issued and the fees has to be paid, then the case has to come back to USCIS. The immigration, the U.S. citizen spouse or the children, 21-year-old children, they needed to apply a case called provisional waiver based on extreme hardship. That means either the U.S. citizen or permanent resident spouse or the parents will be, that means this U.S. citizen spouse children will face extreme hardship if their non-immigrant, non-citizen spouse or the parents have to leave the country. So the extreme hardship can include financial extreme hardship, mental hardship. So there need to be evidence collected to demonstrate. For example, if the children, the U.S. citizen children, has some health problems, needed special care, and the parents are the person to take care of these children. So that can show this will present extreme hardship to the U.S. citizen children or the spouse. So I just want to share with you, this is one way for the people who are not benefits to any other solutions. This may be one of the solutions. Okay, thank you. John will take over.
A couple things to cover. Thanks, Eva. Thank you, Eva. So, a couple final points to make, and this is basically, you have no other options, okay? You can't qualify for asylum, SIJ, T, U, VAWA, okay? You're like, what do I do now? How can I stay in this country, okay, under these circumstances, okay? Well, there you go. There are three ways, okay? Dismissal, okay? No NTA issuance, okay? And administrative closure. This is something that the Biden administration has taken up, okay? So the issue with the Biden administration is we're now over 1.6 million cases in the immigration court system, okay? Probably closer to 1.8, 1.9 now, okay? In fact, just as an example, ladies and gentlemen, in New York City, they're scheduling merits hearings, okay? Individual hearings, 10 years from now, 2033, before their cases are heard. That's New York, okay? I guarantee you Los Angeles, San Francisco, Miami, Baltimore, okay, Seattle, probably facing very long deadlines as well before those cases are heard, okay? So the Biden administration has decided we have too many cases in the pipeline, too few immigration judges, too few ICE attorneys who are doing these cases, plus the appellate process, plus going to court, okay? So what are we gonna do? Decisions made that they're gonna exercise prosecutorial discretion, or PD, as we call it, okay? This is similar to what Obama administration did with PD back in 2012 to 2016, or early 2017, okay? What they're doing is deciding, okay, if you received a notice to appear, an NTA, okay? If you arrived in this country, okay, either as an entry without inspection, or you committed a crime, or you overstayed your visa, and ICE identified you, you almost certainly received an NTA, okay, notice to appear. if you received an NTA, what the government's deciding is if you are a good moral character and you have no criminal record and you're doing the right thing, okay, then they're deciding basically as a matter of individual discretion, okay, whether to grant your request, okay, it's called a motion. You're moving immigration court, okay, to dismiss your NTA, your notice to appear, okay. So what does that mean? Well, first of all, ICE has to agree to it, okay. You can file an individual motion, but immigration judges generally are not granting these motions unless ICE either joins in a motion, files what's called a joint motion, or doesn't object to a motion to dismiss, okay. If ICE does object, okay, chances are an immigration judge is not going to grant it. But what the offices are being, especially Baltimore, is deciding is we have too many cases in the pipeline, too few attorneys, too few immigration judges hearing these cases. We don't want these cases dragging, being heard 10 years from now. That's just not working. So they're deciding as a matter of discretion, prosecutorial discretion, we're not going to pursue these cases. Which means if your motion to dismiss is granted, then there is no outstanding NTA against you. That means you're no longer in immigration court. Okay? That's the beauty of it. You're out of immigration court. Okay? That's the first thing. The second thing is that if ICE is on the fence in terms of whether to grant you, whether to issue an NTA against you, you can ask ICE to say, look, you know, I came to this country, I'm applying for asylum, I'm doing the right thing, okay? Until my asylum application is resolved, would you agree not to file and issue an NTA, okay, against me? Okay? It's discretionary, okay? And there are immigration judges that are agreeing, okay, we're not going to issue an NTA against non-citizens coming to this country, okay, as a matter of discretion, okay? Now, that does not give you a get-out-of-jail-free card indefinitely, because they can go forward with filing an NTA, especially if your asylum application is denied, okay? The chances are you're going to have an NTA served on you and filed with the immigration court, okay? The third thing is the third measure, okay, is called administrative closure, or admin closure. This is something the Obama administration did and what Biden administration is picking up and doing. So admin closure, the equivalent, okay, is in federal and state practice in Maryland is referred to as the STET docket or the suspended docket, okay? Yeah, there's this case out there against you, but you know, we're not going to take it. We're just not interested, okay? We're just going to hold it out there, okay, in abeyance, just to suspend it out there, okay? But nothing's going to happen. We're just going to administratively close the case, okay, like the STET docket, and just leave it out there, okay? So that, you know, there's not going to be any sort of immediate removal proceedings against you. They're not going to call you in for master calendar. They're not going to call you in for individual hearing. You're not going to be deported. But that NTA is still out there. It still exists. It's just closed. You understand? It's closed. Now, people say that's great. Well, it's great for now. But if a new president comes in, that could end. And for example, when Trump came in after Biden, sure, okay. So when Trump came in, he's like, yeah, the Obama administration may have done administrative closure. We are reviving these cases, which meant those administrative closures ended, and now those cases were back on the active docket, okay? And those people, okay, faced deportation or removal from the United States, okay? That's admin closure, okay? So if everything else fails, okay, you really, you're a person of good moral character, you're doing the right thing, you're filing for some type of relief, okay, you have three options at your disposal while the Biden administration remains in office, okay? Dismiss the NTA, non-issuance of the NTA, or administrative closure, okay? Eva, did I miss anything, or? Okay. I would suggest with all this said, I know there's a lot of information, okay, that you try to obtain counsel. Under federal law, when it concerns immigration, non-citizens are entitled to counsel. They can't obtain counsel, but the government will not pay for your attorneys, okay? You either have to pay for your attorneys yourself, private bar, okay, or find, a non-governmental organization, NGO, that will take your case. As an example, Catholic Charities, HIAS, Casa de Maryland. I know there are many others, but there are many other organizations out there. Montgomery County Bar Foundation, okay? We'll make referrals to have attorneys who will work your case, okay? They either would do the case pro bono, which is for free, or low bono, which is a reduced rate. But if you decide to pursue, your claim, okay, in immigration court, I highly encourage you to obtain counsel. I'm not saying that because I'm an attorney trying to get business, okay, because I retired from federal service. What I'm saying is, it's very complicated and it's filled with landmines, okay? A lot of people make missteps, okay, and they're out, okay? You don't want to be one of those people that gets left out because you made a mistake. So I encourage you, if you can, find an attorney who's willing to take your case, or an organization that's going to take your case, so you can pursue the relief to which you may be entitled to. Okay? Does anyone have any questions in the few minutes we have remaining? Any questions? Okay. I want to thank you all. You've been a great audience. We'll be doing clinic, so we'll be happy to hear individual matters concerning immigration cases. But I want to thank you very much again for your time and attention, and have a good afternoon. Thank you.
Test 1 2. Test 1 2.
Hello? Okay. Test 1 2. Okay. All right. Hello again, everyone. Again, my name's Zoe. Thank you all for being here today. And thank you to our lawyers for presenting that immigration workshop. As a reminder, we have class registration at the back there. If you'd like to sign up for ESL, GED, or digital literacy classes, the last call for testing will be 3:45 p.m. So sign up and test if that's if you want to do that before you leave. 3:45 is the last call for that. We will be having another legal workshop that will be presented at 3:30, but we're going to have a little bit of a break, and we'll have a couple of our vendors and partners come up here and talk a little bit about the work that they're doing. So we hope you stick around for that.
Hi. All right, good afternoon, everyone. I'm James LeBlanc from WorkSource Montgomery. And WorkSource Montgomery is Montgomery County's official workforce development agent. And we connect job seekers to employment. So we have jobs in any industry you can think of: healthcare, hospitality, construction, IT, transportation, anything you can think of. And we also have funding for training in case you want to upskill in your current occupation or switch careers altogether. If you enroll in our program, we have up to $5,000 of training dollars for each individual. So there's a lot of options at WorkSource Montgomery. Our table's right there with the black tablecloth. And again, I'm James LeBlanc. All of our services are free also, I forgot to mention. So thanks for listening, both of you. A question. I don't speak Spanish. Muy poco. Okay.